Hello everyone, welcome to this video where we'll discuss and analyze the legal perspective of same-sex marriage petition which is currently being heard by the Supreme Court of India by a 5-judge constitution bench led by the Chief Justice of India. So in this discussion, we'll try to understand the legal nuances with respect to the Special Marriage Act because one of the provision of Special Marriage Act has been challenged. So first of all, we need to understand that what is the petitioners with respect to the same-sex couples are trying to seek, or what are they seeking from the Supreme Court, and what is the argument of both the petitioner and also that of the government. So first of all, the petitioner is trying to seek recognition of the same-sex couples with respect to marriage. That is, they should be able to marry and their marriage should be recognized by the state and also registered by the state under the Special Marriage Act. On the other hand, the state or the government, that is the union government, is saying that this aspect of adjudication, whether recognition of same-sex marriage to homosexual couples or same-sex couples, is the domain, or recognition of their marriage and the registration of their marriage is the domain of the parliament and not that of the court. So these are the two basic premises on the side of the petitioner and also on the side of the government. So here let us understand the basics first. Now, to understand this petition with respect to application of same-sex marriage or registration of homosexual couples for same-sex marriage, we need to understand the Navteej Singh Johar judgment pronounced in 2018. Now, in that judgment, the Supreme Court declared Section 377 of IPC as unconstitutional with respect to consenting adults. Now, the petitioners claim that once Section 377 of Indian Penal Code has been decriminalized, hence the homosexual couples and the heterosexual couples, both these categories lies on the same plane. That is, there is no difference between homosexual couples and heterosexual couples once Section 377 of IPC has been declared as unconstitutional. And since homosexual couples stands almost on equal footing to that of heterosexual couples, hence just like the homosexual couples, then just like the heterosexual couples, even the homosexual couples should have the right to marry. And their right to marry, that is their right of marriage, should be recognized by the state and also should be registered by the state. So this is what basically the petitioners are claiming. And on that ground, the petitioners have challenged one of the provision, that is Section 4C of Special Marriage Act, because this provision mentions about marriage between a man and a woman with respect to their age. So the petitioners are claiming that this provision should be declared either as unconstitutional or should be read as gender neutral. Now, other than the claim of the petitioner, obviously the government is against this claim because the government believes that it's not merely marriage, but recognition of marriage will lead to other aspects of life, such as aspects of divorce, aspects of succession, in case the married homosexual couples end up adopting some of the kids or some of the child, aspects of adoption, aspects of, say, wills or inheritance. So all these things needs to be regulated. And since in India, these aspects of personal laws are regulated by different religion, hence it is ultimately the domain of the parliament, that is the legislature. And the code should not adjudicate on these matters because it may lead to violation of separation of power. So this is one of the set of arguments of the government. Now, since these aspects of divorce, succession, adoption, etc., this forms part of concurrent list, and accordingly various state governments can have legislated certain different rules, particularly with respect to the Special Marriage Act. So it says, so entry 5 of the concurrent list mentions about marriage and divorce, infants and minors, adoption, wills, intestacy and succession, joint family and partition, and other issues. So, since it's a part of concurrent list, and recognition of marriage for homosexual couples will also lead to further rights or associated rights. Hence, the states have also argued that all other states, that is, the union government has argued that all states and union territories should be made party to this particular proceeding. Now, here we need to understand about the Special Marriage Act. As I've stated that in India, marriage laws are governed by specific personal laws of different religion. Now, this Special Marriage Act provides a special form of marriage in certain cases, mainly where the consenting adults, that is man and wife, are from different religion. And this Special Marriage Act provides for the registration of such marriage, right? So it is here where the homosexual couples or the same-sex couples have demanded in this petition that they should have the right to register to marry, first of all, and also that their marriage is recognized by state, and third, the state should also register their marriage, which obviously the union government has not agreed to. And the union government in its argument so far has stated that they are ready to recognize their relationship but not recognize or register in a form of marriage. Now, there is another aspect in this particular petition, and this aspect is regarding the notice of 30 days which has to be provided under the Special Marriage Act. So under the SMA, it says that a couple has to give a notice of 30 days before date of marriage, and the petitioners have stated that this violates the right to privacy, which has been declared as a part of Article 21 of the Indian Constitution in the famous K.S. Puttaswamy judgment. Further, this notice also have to be publicly displayed in the office of marriage officer. Now, this not only affects someone's right to privacy, but it also impacts right to choice, because ultimately right to marry someone is someone's personal choice. And if someone is marrying under the Special Marriage Act, then they have to declare that they are marrying someone, and that declaration has to be put in public notice. So this provision has also been challenged in this particular judgment. Now, another important point to be noted here is Section 50 of Special Marriage Act. Now, as I've stated that since the impact of marriage goes beyond marriage, it leads to adoption in case of homosexual or procreation in term for the heterosexual couples. So ultimately, it's not mere marriage, because with respect to marriage under any personal law, it leads to creation or having a family of one's own, then a child. So marriage generally leads to other associated rights, right? Now, this particular provision, that is Section 50 of the Special Marriage Act, allows the state governments to make rules for carrying out the purposes of this act. So we have seen that different states have different rules for marriage or registration of marriage under the Special Marriage Act. So these rules have to be uniform, because it's not possible, say, that some of the states allow for Special Marriage Act, allow for marriage under the Special Marriage Act for same-sex couples, but some other states do not allow. So there has to be uniformity, and that's why the union government has argued that all the states and union territories should be made party to this particular petition. So in this petition, that is the Supriya Chakraborty and others versus Union of India, a writ petition has been filed under Article 32 of the Indian Constitution, challenging Section 4C of Special Marriage Act. And this particular provision provides for conditions relating to solemnization of special marriages. And one of the conditions provided is that the male has completed the age of 21 years and the female has completed the age of 18 years. And this is what the objection of the petitioners are, that this term male and this term female should be made gender neutral, such as the word spouse can be used or the word partner can be used. And other than this, the same-sex couple should also have the right to marry under the Special Marriage Act, and their right to marriage should be recognized by the state. So here two things are important to be understood. These two things are recognition of right on one hand and exercise of rights. So for example, just saying hypothetically, suppose the Supreme Court recognized right to marry as a part of fundamental right under Article 21. Fine. So the Supreme Court recognizes right to marry under Article 21. But how do you exercise this particular right? So there is a difference. That exercise of rights means two couples, maybe of same sex or different sex, should be able to marry in the society, and their marriage is recognized or approved not only by the society but also regulated by the state. And it is here where the Chief Justice of India has observed that since the aspect of marriage is regulated by the state at hand through various personal laws and also the Special Marriage Act, hence with respect to anyone's marriage, it is the corresponding duty of the state to provide them certain protection. First of all is to recognize their marriage. So on one hand there is recognition of rights, and on the other hand there is exercise of these rights. So the petitioners are claiming that it's not merely recognition of their right to marry, but their right to marry should also be recognized by the state, and also they should be able to exercise their rights. And accordingly, under the Special Marriage Act, their right to marry they should be able to register their marriage. So this is what they actually seek from the Supreme Court. And based on this, the petitioners have claimed that since right to marry is recognized under Article 21 because it's also related to their choice, and marriage is also involves a certain element of privacy. Hence, it involves quadrangular rights under Article 14, under Article 15, under Article 19, and under Article 21 of the Indian Constitution. Why 14? Because both homosexual couples and heterosexual couples are on the same plane, especially after decriminalization of Section 377 of Indian Penal Code. Article 15, as there cannot be any discrimination on the ground of sex. Article 19, with respect to right to freedom of speech and expression. And also Article 21, with respect to personal liberty, right to life and personal liberty. So these are the quadrangular rights under which the homosexual couples are seeking that right to marry gets covered under these constitutional provisions. So I'm sure you are aware about Article 14, which talks about equality before the law. Article 15, prohibition of discrimination on grounds of religion, race, caste, sex, or place of birth. Article 19, which mentions about freedom of speech and expression, and also right to reside and settle in any part of the territory of India. So these homosexual couples also have a right to reside and settle in any territory or any part of the territory of India. And of course, Article 21, which mentions that no person shall be deprived of his life or personal liberty except according to procedure established by law. So these are the quadrangular rights which the petitioners seek, and the petitioners have also stated that recognition of right to marriage under the fundamental rights will be in sync with Article 16 of UDHR, that is Universal Declaration of Human Rights. Now, important point to be noted here is that Article 16 Clause 2 mentions about marriage shall be entered into only with the free and full consent of the intending spouses. Now look at the term. The term used here is gender neutral, that is spouses, not a man or a woman. So recognizing right to marriage of homosexual couples or couples of same sex will also will make it in sync or in synchronization with Article 16 of Universal Declaration of Human Rights. Now, as I've already stated that this whole argument starts from the Navteej Singh Johar judgment, which decriminalized sexual relations between consenting homosexual adults, also between lesbians and other sexual minorities. So the term here is LGBTQI++, etc. Now in the Nalsa judgment, the Supreme Court declared that transgenders are the third gender. So there is a possibility that two men, want to marry each other, or two women wants to marry each other, in this case of same-sex couples, or two transgenders wants to marry. So for all these, they are recognizing or asking that the state should recognize their marriage and also provide registration under the Special Marriage Act. Now here the Supreme Court has very categorically stated that we will not go into the aspect of personal laws, that is the various laws with respect to marriage, with respect to alimony, succession, maintenance, etc. because different religions have their own set of laws. So here the Supreme Court has very clearly said that we will only hear the case, or rather we will limit this case only to Special Marriage Act. And here the Union government has stated that there are other aspects of personal laws which may get impacted, and it's not that easy, that it's not mere recognition of the rights to marry, but there are other associated rights or other rights which flow from marriage. For example, let's take an example here. Suppose these two couples, these two women adopt a boy. So the aspect of adoption comes into picture. Now these two women are working, and in their lifetime they inherit certain property, and later they also adopted a girl. So how will this property be divided between the boy and the girl? So there has to be a law, and that law has to be made by the parliament, right? Similarly, there would be cases of maintenance, there would be cases of succession. There's possibility that these two people, say tomorrow, or some other couple, do not find compatibility with each other and want to file a divorce. So what should be the proceedings for divorce? So all these things should also be looked into, and it's not only that recognition of marriage will solve all their problems. So this is what the Union government is arguing, that ultimately we have to look into matters beyond their marriage. Now the petitioners have stated some of the very important highlights from Puttaswamy judgment, as it recognized right to privacy as an important facet of Article 21. Although state can make reasonable restrictions or put reasonable restrictions on privacy. So here the judgment says that privacy includes at its core the preservation of personal intimacies, the sanctity of family life, marriage, procreation, home, and sexual orientation. Now privacy safeguards individuals' autonomy and recognizes the ability of the individual to control vital aspects of their life. That also includes right to marry. And privacy attaches to the person since it is an essential facet of the dignity of the human being. So and personal choices governing a way of life are intrinsic to privacy. So the elements of choice has been provided or has been highlighted in the case Puttaswamy judgment. And based on this, the petitioners have claimed that they have a right to lead a dignified life, that is, a life full of dignity, a life without social stigma. And this social stigma, especially on the same-sex couples, can be removed if their right to marriage is recognized by the state. So this is what the petitioners have claimed. So summarizing the claims of the petitioner, they say that rights of couple of same sex are equal in all forms with heterosexual couples after decriminalization of section 377. Hence, they are same in every manner, and accordingly, they should also be granted the right to marry just like the heterosexual couples. So it says that if the rights enjoyed by such couples are equal with heterosexual couples, then they want to enjoy the full canopy of rights under Article 14, 15, 19 and 21. Same-sex couples wants to lead a full life with dignity, privacy and without the stigma and not mere animal existence. So their life should be meaningful life and not mere animal existence, and their life should be their life under Article 21 should be they should lead their life with dignity and also the elements of privacy. Hence, they claim that dignity, equality, secularism and plurality goes hand in hand and can be associated with quadrangle of rights provided under Article 14, 15, 19 and 21. And accordingly, the petitioners have sought a declaration from the court that to extend the right of marriage to consenting adults across bodily, gender and sex spectrum, including the transgenders. Such right of marriage is recognized by state. Such marriage can be registered under the Special Marriage Act 1954, and such legal recognition of marriage will lead to societal recognition and will help to remove societal stigma attached with LGBTQI couples. So this is what is the claim of the petitioner. And also because they say that other than the fundamental rights, marriage comes along with a bouquet of rights. And these bouquet of rights include financial rights, like opening of joint bank accounts, claim of gratuity in case of death of one of the spouse. Now, as of now, these same-sex couples cannot claim these benefits. They cannot open a joint bank account. They cannot claim income tax benefits, which a normal husband and wife can claim. They do not have joint property rights. They cannot claim tax benefits. There can be issues of succession, adoption, medical and other insurance, rental accommodation. It is very difficult for these same-sex couples to get rental accommodation across the country. And right to gift to one spouse under Income Tax Act. So basically, they do not enjoy these bouquet of rights. And right to marry under the Indian laws, particularly under the Special Marriage Act, will allow them all these associational benefits which a heterosexual couple enjoy. So their point is that if the heterosexual couple enjoys these things, then why not they should also enjoy the same bouquet of rights. Now these are, as I've stated, that the personal laws including marriage, divorce, succession, inheritance, etc. are governed by different set of laws for different religion. So these are those different laws for different religion under which various aspects of marriage, succession, divorce, alimony, maintenance, etc. are governed. So this particular petition is confined only to the Special Marriage Act and not to these specific personal laws. So this point is to be understood. Now, however, the government has raised certain concerns. The government has said that can the judiciary confer socio-legal rights through legislation? Because ultimately, even granting of these rights and exercise of rights will impact various other aspects other than marriage and including marriage. So it says that consequential impact of marriage of same-sex couple not covered by Indian laws, as it considers marriage as a solemn union between a man and a woman. Now, if you look at all these personal laws of different religion, all of these different laws with respect to marriage or succession or inheritance, etc., is based on the recognition that marriage takes place between a man and a woman, and because of this, procreation takes place and children are born, and based on this, elements of succession are governed by various personal laws. So all these laws, including the Special Marriage Act, is based on the notion that marriage is a union between a man and a woman. And accordingly, so far, the Indian laws do not consider same-sex couples in the form of marriage. Hence, the Union government has argued that they are ready to provide certain sort of legal recognition to same-sex couples, but not marriage. That is, they are not ready to provide this institution of marriage to the same-sex couples. Now, this is what the argument of the Union government has been so far. Further says that all states and UTs must be made party to the petition, and there is no fundamental right in seeking recognition of a relationship as a marriage. So again, the question here is with respect to right to marriage. Now here, while arguing, the Supreme Court has highlighted or rather raised an important point by asking that whether right to marriage is a constitutional right or whether it is a statutory right. Now so far the judgment has not come, the final judgment has not come, and the argument is still in the process. So let's wait for the final decision of the Supreme Court. But this is a very interesting question about right to marriage. And the next aspect is how this right of marriage will be exercised in the society, or rather, how will it be regulated by the state, particularly for the same-sex couples. Now, so far the government has, agreed to form a committee under the chairmanship of Cabinet Secretary, because according to the Union government, aspects pertaining to various ministries are involved, such as Ministries of Social Empowerment, Ministry of Women and Child Development, etc. And Indian says that a committee shall examine whether certain legal rights can be granted to the same-sex couples without legal recognition of their relationship as marriage. So the Union government is not ready to recognize the relationship between two same-sex couples in the form of marriage, but they are willing to accommodate certain legal rights to these same-sex couples. Now, so far we have mentioned about same-sex couples and their right to marry, whether their right to marry is a statutory right or a constitutional right. It's also important to understand that same-sex marriage has been approved by other countries also. It's not that it is a novel concept in India, because this aspect of rights has been recognized by other countries, as you can see in this map. All the blue colored countries have recognized same-sex marriage. And if we talk about UK and US particularly, then we see that the Marriage Same-Sex Couples Act 2013 in UK extended marriage to same-sex couples in England and Wales. Respect for Marriage Act of United States of America, it requires all states to recognize same-sex marriage performed even in other states, and federally recognizes these marriages. So, progressive legislations have taken place in various corners of the world. Now in Switzerland, interestingly, there was a referendum with respect to provision of marriage for same-sex couples, and was passed by nearly 2/3 majority. And Taiwan became the first Asian country to approve a legislation legalizing same-sex marriage. So there are certain countries which has approved same-sex marriage through legislation or through referendum. So it's important to see whether the Supreme Court actually grants the right to marry to same-sex couples and also directs the state to register their marriage. So let's wait for the final judgment of the Supreme Court.